Hello, and welcome to our presentation on violence against women. My name is Nicole Briones.
And my name is Marissa Ball, and Nicole and I are both student attorneys for the University of Chicago Law School's Global Human Rights Clinic, and we're looking forward to giving our continuing legal education presentation on violence against women. Some topics we'll be touching on today are: what exactly does violence against women mean? How it can be so pervasive throughout a woman's life, some relevant international legal mechanisms, and some more recent trends women's human rights advocates have been pursuing.
Great, thank you so much, Marissa. So to start off with, we wanted to provide some context of what we mean by violence against women. The UN definition is any act of gender-based violence that results in or is likely to result in physical, sexual, or mental harm or suffering to women, including threats of such acts, coercion, or arbitrary deprivation of liberty, whether that's occurring in the public or in private life. Now, the focus of violence against women is a recent effort that women's advocates have been trying to bring focus on the national and international level about the pervasive problem of violence against women. Now, for context, gender-based violence occurs throughout the lifetime of many women's lives. This occurs before birth and during infancy. In cultures with some preference, females are targets of practice of self-select abortions and infanticide. As a child, this manifests through forced malnutrition, unequal access to medical care, as well as physical and emotional abuse. As adolescents, this takes the form of early childhood marriage, incest, FGM, the sale of them by their parents for prostitution or forced labor. Now, marriage during the time is often associated with violence during the courtship process, marital rape, dowry violence, domestic murder, forced pregnancy, abortion, and sterilization. Towards the end of many women's life, they are abused and suffer violence because they are widows. Now, to provide just how much of an issue this is on the global scale, globally, 25% of women have experienced violence, whether it's sexual, from an intimate partner or from a non-partner. 137 women are killed by a family member daily. Adult women account for nearly 49% of all human trafficking victims globally. In 2019, it is reported that 1 in 5 women aged 20 through 24 were married before the age of 18. Around 200 million women and girls aged 15 to 49 have undergone FGM, concentrated in 31 countries where the practice is most pervasive. 15 million adolescent girls worldwide aged 15 to 19 have experienced forced sex. So as you can tell, these numbers are staggering. So the question is, why is gender-based violence so pervasive? I think that the first UN Special Rapporteur on violence against women puts this in a good framework, and it gives a new perspective. Violence against women in general, and domestic violence in particular, serve as components in societies which oppress women. Since violence against women not only derives from, but also sustains the dominant gender stereotypes and is used to control women in the one space traditionally dominated by women, the home. Now we will shift to international legal frameworks to address these issues.
To begin, the Convention on the Elimination of All Forms of Discrimination Against Women, also known as CEDAW, is an international treaty that was adopted in 1979 by the United Nations General Assembly. The convention was the culmination of more than 30 years of work by the United Nations Commission on the Status of Women. CEDAW has been ratified by 189 states, but over 50 countries that have ratified the treaty have done so subject to certain reservations, declarations, and objections. Described as an international Bill of Rights for women, CEDAW defines what constitutes discrimination against women and sets up an agenda for national action to end such discrimination. Article 1 of CEDAW defines discrimination against women as any distinction, exclusion, or restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. By accepting the convention, states commit themselves to undertake a series of measures to end discrimination against women in all forms, including to incorporate the principle of equality of men and women in their legal system, abolish all discriminatory laws and adopt appropriate ones prohibiting discrimination against women, to establish tribunals and other public institutions to ensure the effective protection of women against discrimination, and to ensure elimination of all acts of discrimination against women by persons, organizations, or enterprises. So, for some historical context, violence against women in the family and society was not an issue that loomed large on the international agenda dealing with the advancement of women when CEDAW was drafted in the 1970s. In fact, there was actually no explicit mention or reference of violence against women in the convention. As a result, women's rights advocates considered it incredibly important to develop a new normative instrument to remedy that deficiency.
So as Marissa said, the new normative instruments that were developed are a declaration and a general recommendation, formerly known as General Recommendation 19. Essentially, this takes the form of two parts. The UN General Assembly adopted a declaration on the elimination of all forms of violence against women in 1993. A little bit before that, the CEDAW committee adopted a detailed general recommendation in 1992 on how discrimination against women includes prohibiting violence against women. Now, what both of these kinds of instruments take the form is that they take the approach that violence that is directed disproportionately against women or experienced overwhelmingly by women is gender-based, and thus is a form of discrimination against women. Now, to conceptualize violence as a form of discrimination against women, we have to make some logical steps. First, the normal way to approach it is whether or not the human rights violation is in particular to being a woman. For example, forced pregnancy might violate, amongst other basic rights, the right to physical integrity, family life, privacy, and is a violation on the premise that is discriminatory, as it is only occurring to women. Second, human rights violations that are gender specific in the sense they are committed or directed against women, at least in part because they are women. This would include sexual violence. Now, there are other rights, human rights violations, to which women are especially, but not exclusively, vulnerable by virtue of their gender. This takes the form of domestic violence, as men can also be victims of domestic violence. Now, there are some limitations of viewing violence against women as discriminatory. Take these two examples, which I hope illustrate this point. What happens in situations where a woman is arrested and detained arbitrarily because her husband was a political dissident? Similarly, what happens if a female POW is tortured in the same manner a male POW is, but she is pregnant? CEDAW coverage is dependent on how squarely discrimination and how we define discrimination fits within these situations. Now, this approach isn't how all of the international courts view this. For example, in the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence, they view violence against women as a freestanding right, that it is prohibited to have any sort of violence against women. There are two specific articles. One is Article 6 guarantees freedom from all discrimination. That guarantees the right for women to be valued and educated, free of stereotyped social and cultural practices based on the concepts of inferiority or subordination. Article 7 states that parties must condemn all forms of violence against women and agree to pursue, without delay, policies to prevent, punish, and eradicate such violence, and changing the law as necessary.
Now we are going to discuss some recent movements or developments that advocates have been pursuing within the realm of violence against women. To begin, a key priority for many women's human rights advocates has been to secure recognition of rape as a form of torture. The first major breakthrough for these efforts was when the Special Rapporteur on Torture included rape in an enumeration of methods of physical torture in his report to the Human Rights Commission in 1986. Another example of progress concerning this issue has been the development we have seen within the European Court on Human Rights. For many years, the European Court tended to characterize rape either as a form of inhuman treatment or as a breach of the right to private life, rather than as torture. In a 1996 case called Aden versus Turkey, however, the court finally found that the rape of a female detainee constituted torture within the meaning of Article 3 of the European Convention. The court stated that rape leaves deep psychological scars on the victim, which do not respond to the passage of time as quickly as other forms of physical and mental violence. The court also went on to explain that rape of a detainee by an official of the state is an especially grave and abhorrent form of ill treatment, given the ease with which the offender can exploit the vulnerability and weaken resistance of his victim. Now, turning to the Inter-American Commission on Human Rights. The Commission found in several of its reports between 1982 and 1994 that rapes attributable to government forces constituted violations of the right to humane treatment, which is assured by Article 5 of the American Convention, without specifying whether the breaches amounted to torture. However, in the case of the Miguel Castro prison versus Peru in 2006, the court finally addressed the question of rape as a form of torture and stated that the acts of sexual violence to which an inmate was submitted under an alleged finger-vaginal examination by several police officers constituted sexual rape that, due to its effects, constituted torture. Additionally, there was a study in 1993 on the work of the Special Rapporteur on Torture, which highlighted some of the ways in which violence against women, especially rape, was largely ignored by the international human rights institutions for a period of time. One example was the failure to discuss the frequency with which rape and sexual assault were used as a form of torture. Rather, the rapes in Bosnia-Herzegovina focused on the harm resulting to ethnic communities and not the harm inflicted on women because of their gender. Similarly, the UN fact-finding in Rwanda in 1994 did not detect systemic sexual violence against women until 9 months after the genocide, when women were giving birth at unprecedented numbers. Another target for recent efforts in women's rights has been domestic violence and due diligence of the state. The public versus private distinction has historically frustrated recognition of the widespread harms occurring to women in the private sphere. What we mean by this distinction is how it's more typical for the state to lag in assuming responsibility within the private sphere, so like marriage, family, the home, as opposed to the public sphere. Most gender-based violence is domestic, occurring within the home, perpetrated by those to whom the woman is closest. Increasingly, international legal interpretations and norms are evolving to define more clearly the positive role and responsibility of the state in preventing abuses perpetrated by parastate or private actors. One example of this due diligence requirement, which maintains that a state can be held complicit where it fails systematically to provide protection from private actors who deprive any person of his or her human rights. So this concept of state responsibility has developed to recognize that states also have an obligation to take preventive and punitive steps where human rights violations by private actors occur. One illustrative case, which shows how a state can fail to exercise due diligence to prevent women's rights violations, is Maria da Penha Maya Fernandes versus Brazil, which was brought before the Inter-American Commission on Human Rights in 2000. Viveiros committed acts of aggression and attempted murder against his then-wife, Fernandes, leaving her paraplegic. The petitioner maintains that the Brazilian justice system had dragged its feet for more than 15 years without handing down a final ruling against Viveiros, and that this is one example of a pattern of impunity in cases of domestic violence against women in Brazil. The commission held that the failure to effectively prosecute constituted a failure of judicial protection under Article 25 of the American Convention. The Commission also emphasized that the state has an obligation under Article 1 of the American Convention and Article 7b of the Convention of Belém do Pará to exercise due diligence to prevent human rights violations. This means that even where conduct may not initially be directly imputable to a state, a violative act may lead to state responsibility not because of the act itself, but because of the lack of due diligence to prevent the violation or respond to it as the convention requires.
Now, thank you so much. This is the end of our substantive material on violence against women. However, we want to go ahead and summarize the 3 substantive points that we hope that you walk away today with. First is that violence against women is pervasive at every stage of a woman's life. Second, there is 3 core relevant international and regional legal mechanisms. First is going to be CEDAW in the General Recommendation 19, as well as the UN General Assembly Declaration on the Elimination of All Forms of Violence Against Women, as well as the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence, which is a freestanding right from the violence against women in comparison to the other 2, which is actually viewing violence against women as a form of discriminatory behavior against women, therefore would be a violation of the treaty. Now, we also wanted to recognize recent movements in the area, which, for example, is classifying rape as torture and also weakening the private and public distinction, which frustrates the protection of women from domestic violence. Now, thank you so much for watching our presentation. We hope that you were able to learn a little bit more about the substantive area and were able to continue on discussions thinking about this in ways to more properly address issues facing women. Thank you so much, and we appreciate your time.